Okay, today we're going to talk about civil liberties and civil rights. Civil liberties are those basic freedoms in the Bill of Rights, and civil rights would be how those are applied. In other words, how are they protected by the government? So that's protections against any kind of discriminatory treatment in protecting those civil liberties by the state. So we're going to look at those, of course, are protected by the Bill of Rights, and we'll talk about the due process clauses in the 5th and 14th Amendments. And of course, they are protected also in legislation, like the Civil Rights Act and the Voter Rights Act. So before we get into it, we need to kind of understand that many of the cases that the Supreme Court will hear are cases about competing rights. Your rights are not absolute. They are limited by usually how it affects others, right? So that saying about, the rights of your fist end at the tip of my nose kind of thing, that your rights are limited by how they infringe on the rights of others. So there's that balancing act. And so we have to look at, which ones in a particular case-by-case basis, whose rights are in that particular situation being violated, okay? And we'll find that the court, sometimes it seems as though they're kind of going back and forth and not making any hard and fast rules. And that's because every case is different. And we'll see that as we go through some of these cases. Some examples of competing rights that really kind of spell that out. Shepard versus Maxwell, and there are links to all of these if you want to go back and read a little bit farther. I'm just going to give you some kind of summaries of these. So Shepard versus Maxwell was about the freedom of press versus the fair trial of Dr. Shepard. So Dr. Shepard was a man that allegedly had killed his wife, and the trial and leading up to the trial was very sensationalized by the media. It was one of those huge trials that everybody knew about. It was in the news every day. It was just constant. It was almost what in my lifetime would have been like the O.J. Simpson trial. It was that media focused, right? So he argued that because of the media basically making a circus out of his trial, that he could not get a fair trial. And so it was, freedom of press. Should they get to just print whatever they want to and, print so many details where his jury might be tainted, or, in some way the trial not being fair. And the media in the courtroom made it very difficult as well. So he argued that he could not get a fair trial. So the court agreed with him because of the particular issues in the case. Now, the court has not always agreed with, or sided against the press in cases like this. But it did sort of set precedents about, things like gag orders from judges to the media and that kind of thing about limiting what they print. All right, so New York Times versus the U.S., that was also known as the Pentagon Papers trial. And basically the argument there was, how much can the media have access to? Should they be able to just print anything that that is leaked to them, even if it puts the country in danger? And we kind of have some issues of that with the Patriot Act and other legislation. So that's, has been adjudicated again and again in specific instances. So the, common defense versus free press, right? Of course, the court in that instance sided with the New York Times and they printed it. So it's really, like I said, case by case. A more recent case is the Masterpiece Cake Shop versus Colorado Civil Rights Commission. And that was the same-sex marriage. The couple wanted the baker to bake them a special cake for their wedding. And the Baker said, no, that's against my religious beliefs, but you can pick out any other cake in the store. I'm just not using my expertise my talents to make you a special cake for it, because that violates my freedom of religion, his religious beliefs. All right. So, whose rights are more important? The discriminatory action against the same-sex couple versus the Baker's religious beliefs. So, and we'll talk a little bit more about that particular case a little bit later. But of course, the court sided with the Baker, and we'll talk about why. And we actually, I think, have mentioned this in class before as well, but we'll talk a little bit more about that. So, as you can see, just from these three cases, it is, whose rights are more important. That's kind of almost seems like what they're deciding, but it's really done on a case-by-case basis. Okay, so quickly talking about federalism before we get into the Bill of Rights. Remember that the Bill of Rights originally only protected against the national government, not the states. The 14th Amendment changed that with incorporating those rights to the states, saying that the states could not deny you life, liberty, or property without due process of law. All right, so there are two views on how that should be done. The total incorporation view would apply all the provisions of the Bill of Rights just straightforward to all the states and change it immediately. Well, that was a view after the 14th Amendment was passed, that they should do that, and they did do that with certain things like the abolition of slavery. And, of course, the incorporation of the 14th Amendment of the former slaves as citizens. But for other individual rights in the Bill of Rights, they were less apt to just say, okay, let's have a blanket incorporation. They ended up, through several different cases, setting the precedence of selective incorporation. And that's basically where only some are incorporated to the states, and it's gradual process over time. To date, almost all of them have now been incorporated, except, of course, for the Third Amendment and the Seventh Amendment. But those are, kind of not relevant at this point. So, but we'll talk about the selective cases that incorporate those amendments to the states. All right. So, also with the impact of federalism and selective incorporation, they have, like I said, on an individual basis, done all of these things here. And we can add to this now the Second Amendment right. And I think I left that one out. But that one was decided in 2010 with the McDonald case. So I always forget to go back and put that in there. But it is now incorporated. So here are the ones, again, that have not, and of course the 10th Amendment, which that is to the states, so that doesn't really apply anyway, but I put that on there just to know that we're not going to be talking about those three as we go through these. All right, so with the incorporation, so how do they decide, how these things are going to be incorporated? Well, a case, Palco versus Connecticut, basically set up the idea that if any right is so important that that liberty couldn't exist without it being upheld by the states, which is kind of quoted as ordered liberty and fundamental rights. So in these cases, the courts have said, okay, without this particular right, basically none of the rest of them matter, right? Because you're not going to be free without this one particular right. So now, with the Palco test, that's sort of what had throughout the history of these cases, had determined whether or not it would be a right incorporated. Okay. So also I want to jump and talk a little bit about the 9th Amendment just before we get into listing the rights, the civil liberties, because the 9th Amendment basically covers things that are not listed in those amendments. So just a couple of examples of different things like the right to privacy, the right to travel freely, freedom of association, homosexual conduct, and other things dealing with things like birth control. We could sort of lump all that in with, that Loving in Virginia and this Lawrence versus Texas, and with kind of the rights in the bedroom, so to speak. So all of those things are not listed really anywhere in that list of rights, but that's what the Ninth Amendment covers, right? So just because it's not written down doesn't mean you don't have that right. So these are some cases, and a lot of these we've already talked about. So that Griswold was about birth control, and that was the right to privacy. Also, we could put in Roe versus Wade with that. Of course, in those rights, it says nothing about abortion, but that's considered the right of privacy. Also, the freedom of association, the Boy Scouts of America versus Dale, that's where the Boy Scouts basically could discriminate against homosexuals because that was the freedom of their association. And then that was their particular group. And if they wanted to discriminate, then they could, basically. Also, Lawrence versus Texas, that struck down sodomy laws in Texas. And then, of course, Loving versus Virginia, down there at the bottom, overturned laws banning interracial marriage. All right, so let's jump in now and actually talk about those listed. So we'll start with the First Amendment, freedom of religion. The first thing we need to talk about is the Establishment Clause. This is where the government may not establish an official religion. So there are a couple of different viewpoints on how it should be done, or what is considered establishing a religion and what is not. So the accommodationist view, that's where the government should bend a little bit and allow certain things as long as they're not overtly showing favoritism or, establishing anything. So, allowing different things as those listed there. Separation is totally nothing, not allowing anything, not bending at all, that wall of separation. And of course, I feel like I need to state this here. Nowhere in the Constitution, in the First Amendment or elsewhere, does it say anything about a wall of separation. That's something that in discussion of it came about a little later. And so a lot of people view that it is more of a freedom from religion kind of thing. And that would kind of be that view of it. Endorsement view just forbids government practices that endorse. So things like, having the nativity scene or 10 Commandments and things like that posted or used in courtrooms or city halls or city property and schools, etc. And then there's the non-preferentialist view, which basically says, okay, you can't favor any one group, but it does allow for some government support in religion. And that the non-preferentialist view has been one that has tended to prevail in court cases. So we'll talk about some of those. Okay, so looking at the Establishment Clause, here are some cases that are typically cited as being kind of the big cases on that Establishment Clause. So the Everson versus the Board, and let me just say this first, this is not obviously all-inclusive. These are just some that are, more well-known, and just kind of giving you also examples of different, kind of random things and how they are incorporated on an individual basis, case by case. All right, so Everson versus Board. This is one that said that the wall of separation exists, and this was in the opinion. So that was obviously the opinion of that particular court that said this wall of separation. And so the Establishment Clause applies to the states via the 14th Amendment. So that incorporated that. But basically, this was the case about allowing New Jersey tax money to pay for transportation. So it did uphold the New Jersey law allowing that, But the importance of this was that it said that a wall of separation does exist. All right. Let's see. Then the Zorach case, 1952, release time for religious instruction elsewhere. Basically, what this was about, some schools would allow students to, part of the day go to, a chapel off campus or things like that for religious instruction. So some of the more parochial schools would have other kids from public schools coming in to participate in certain things they did, and can public schools allow them to be released for those things? Some complain that they shouldn't because that favors that student and their religion. The court did not agree with that. They said that it was constitutional because it didn't overtly, call for any kind of support by the government. All right, a big one. This is the biggest probably case out of this list, or one of them, the Engel versus Vital. This is the school prayer in school case, a significant one, and this, of course, is on your required list. So basically, this is what did away with a school-sponsored prayer, okay? Because that, used to when you would come in to school, the teacher would lead in a prayer or a Bible verse or a devotional kind of thing, or they would say a prayer over the loudspeaker every morning when they said the pledge. All right, so that they said that was unconstitutional, that the teachers couldn't lead you in a prayer or principal or anything else set aside specifically for prayer at school. All right, then Abington, no devotional or Bible reading, kind of went along with that or followed it up. Epperson versus Arkansas, this prohibited the teaching of evolution in public school. That was a state law in Arkansas, and that law was viewed as being the government saying that evolution was not the endorsed view that creationism was. So that law prohibiting that teaching of evolution basically amounted to establishing an official belief. All right, and then this one is very important as well, the Lemon case. So the Lemon case kind of sets a precedent called the Lemon test. So Pennsylvania had the state could reimburse non-public schools, in other words, those parochial Christian schools or any sort of religious schools, for things like teacher salaries, textbooks, and things like that. And so that was challenged as the government endorsing that religion when taxpayer money could be used for it. The court said that taxpayer money could be used for or in parochial schools if it didn't specifically go to involvement in the actual religion, right? So in other words, if it's non-secular, like busing, if that kid would get it at the public school, the same thing at the private school or the parochial school, then they could receive taxpayer dollars for it. So if it was busing or even books, as long as they weren't religious books, the electricity for the school, things like that weren't overtly religious in nature. So that's the Lemon test to determine if it's okay. All right. So the Zellman case, this was public money being used to send disadvantaged kids to religious schools with vouchers. This is that voucher case, and that so public money can be used if the child chooses to have a voucher to get out of the public school and go to a better school. That's kind of that school choice case. So the second part that we need to talk about is the free exercise clause. So we talked about establishment. Now, these cases have to do with how people worship. All right, so this is that freedom of worship. There is a contradiction possibly on some of these because if certain things are allowed, that may be the government establishing a religion, so or preferring a religion or favoring a religion. So they are very careful about how they rule on these. So freedom of worship is relative and not absolute. So there are some things that the court has upheld, like polygamy laws and things like that, age requirements for marriage and things like that people have cited, freedom, free exercise of their religion. So the courts are very careful on that as well. Okay, so what happens when a case like this goes before the court is that the proof of whether or not this is an actual tenet of your religious beliefs and not just an excuse, basically, that burden of proof is on the religion. All right. So one example is this employment division of Oregon versus Smith. So basically this guy, he's using peyote, which is a hallucinogenic, like cactus flower thing. And so he was using that. He got caught with a drug test and was denied benefits, unemployment benefits, because he failed the drug test. So he said, well, that was part of my religious belief. So he should be able basically to do this drug because it's part of his religious beliefs and they can't deny him his unemployment benefits. Well, the court said, well, you need to prove that it's part of your religious beliefs. Well, there was no doctrine or anything that he could pull out and show, oh, this is my religion has been doing this for years or what have you. So the burden of proof is kind of switched to the person or the petitioner. Some other restrictions, the polygamy, I already mentioned that. The Amish in U.S. versus Lee said they didn't have to pay Social Security taxes because of their religious beliefs. Of course, the court said, no, you have to do that. Some other examples, the Jehovah's Witness said that they shouldn't have to salute the flag because it's against their religious beliefs. That was back when everybody was forced to basically say the Pledge of Allegiance. So the court ruled for Jehovah's Witness. They don't have to say it. Wisconsin versus Yoder. This is one of our required cases. This established that the Amish did not have to send their children to school past the 8th grade, regardless of the laws in that particular state, because of their religious practices. So they were able to show that that is part of their religious practices. So that burden of proof was still on the petitioner. So the bottom one down here, the Church of Lukumi, I guess is how you pronounce that. I say it wrong every time. But anyway, this was in New York City. This guy basically was caught sacrificing an animal in the city, and that was against a city ordinance about slaughtering of animals. And so he was arrested on it, and he was able to prove to the court that that was part of his religious beliefs, so that law was struck down when used for animal sacrifice or religious beliefs. All right, so we will pick up here next time with freedom of speech.